Nice to meet you. Basically, just right at that little prick in the book. Last year, again, or last night.
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is in re K.P.W. I'll note that Justice Riggs is recused in this case, and we will hear from the appellant.
Mr. Chief Justice, Associate Justices, good morning and may it please the court. I am Erica Hamby and I am appearing on behalf of the Wilkes County Department of Social Services, along with my colleague Michelle Formey-Duvall Lynch, representing the minor child, and on behalf of the GAL, we represent the appellants in this matter. We plan to split our time equally and would like to reserve 5 minutes for rebuttal. There are 2 issues before the court today. First, I will address that the Court of Appeals erred in finding that the amended petition did not initiate a new termination proceeding as to the respondent father, and that in fact it did, as Justice Dillon held in his dissent, and that preserved or resolved any issues as to any deficiencies that may have occurred pursuant to 7B1105. Additionally, we hold that 7B1105 was followed. Secondly, my colleague will address that the respondent father has failed to show prejudice as to any of these alleged deficiencies as to 7B1105, and that the Court of Appeals overstepped its authority, addressing the grounds for termination when respondent father did not challenge those grounds on appeal. This matter started in June 2018 when the Wilkes County Department of Social Services, pursuant to a neglect petition and a contemporaneous non-secure order, took custody of the minor child and her siblings. At that time, the purported father was the father listed on the birth certificate for all of the children. It was not until a permanency planning review hearing in July of 2019, over a year later, that any questions as to paternity to this child arose. At that time, the district court judge ordered that the purported father submit to DNA testing to confirm paternity. Subsequent hearing in September 30th of 2019, the presumptive father had not submitted to 2 DNA tests at that time. The court further ordered him to submit to a DNA test in October of that year. It's also to be noted that at that September 30th, 2019 hearing is the first time that a picture of the child appeared in the record, and that was as part of the GAL's report. The presumptive father submitted to DNA testing in October. It was determined that he was excluded as a potential biological father for the minor child. After that was determined, the department filed a TPR petition on 11/26/2019, naming the purported father and a John Doe. At this point, no other person had ever been identified as a potential father for the minor child. Respondent mother was not served with that TPR petition until 37 days after filing, on January 2nd, 2020. After learning that she had been served, the department noticed this 7B1105 hearing on January 24th, 2020, for that to be set on February 10th, 2020. Intervening that notice and the hearing on February 10th, social worker met with the respondent mother in jail, and on that day, January 27th, 72 days, I believe, after the petition had been filed, was the first time, 62 days, I'm sorry, was the first time that the respondent father's name was ever mentioned as a potential biological father for this minor child. The hearing was held on February 10th, and at that hearing, the department informed the court that there now had been a named father, or a named potential father. Despite what the Court of Appeals opinion states on the slip at pages 11 and 12, there was in fact an order entered within 30 days from that 7B1105 hearing on February 10th. That order was entered on March 9th, 2020, and the order found that the department should proceed with DNA testing as to the named potential father, and if he were determined to be the father, to then file an amended petition. The respondent father was located in April of 2020, informed that he was potentially the child's biological father. He agreed to DNA testing. When he was located, he was incarcerated. He was scheduled to get out and was scheduled for DNA testing in May of 2020. He was released from jail, did not appear for that testing in May of 2020. He was subsequently re-incarcerated and was in the Department of Adult Corrections. And obviously, this was during the time of COVID, so there were restrictions on who could go into these DAC facilities and how they could get to in contact with prisoners. So between June 2020, November 2020, December 2020, unfortunately, DNA testing was unable to be performed due to his locations and the COVID restrictions. Respondent father was finally DNA tested February 6, 2021, and informed on February 22nd, 2021, that he was definitively the biological father of the minor child. Approximately 8 months after he was determined to be definitively the father and informed, the Wilkes County Department of Social Services filed an amended petition naming him as the father and alleging that he had abandoned the child for 6 months preceding the filing of the petition. It has long been held by this court that an amended complaint supersedes the original complaint and initiates a new action. That was first held, the best I could find, first held by Zager in 1914, so over 100 years ago. It was then adopted by Burrell in 1956. Notably, both of those were before the promulgation of the Rules of Civil Procedure in 1970, but neither one of those specifically, as to this point to statutory authority. Zager in 1914 appears to point to a treatise that I, from the best of my ability, can determine to be the Encyclopedia of Policy and Procedure. But the court nevertheless adopted that at that time, an amended complaint supersedes and stands in place and begins a new action.
Can I ask you what your view is regarding the application of 7B1105 and particularly subsection B to the facts here, and in particular when you told us that the court first learned of the father's, the respondent father here learned of his name on February 10th, am I?
The court first learned of it on February 10th. The department learned about 5 days prior, well, I'm sorry, maybe 12 days prior to that on January 27th was when the department first learned, and the court learned on February 10th. Yeah.
And these are 2020?
Yes, ma'am.
And so why wouldn't that mean that subsection B here applies? Should the court ascertain the name or identity of the parent, it shall enter a finding to that effect, and the parent shall be summoned to appear in accordance with 7B1106. Why, at that point, doesn't this statute direct the court to find this person named as a parent and summons him? He can then be ordered to have the DNA testing. He can then be appointed counsel, and the process can proceed. And if the DNA testing determined he's not the parent, he would be dismissed in the same way that the original putative father was dismissed.
Thank you. There is actually a very good answer to that. One, 7P1105B says ascertain. Ascertain means with certainty. There was no certainty at this point that he was the father. Also, 7B1105E gives a provision that we say that the court followed in this case, where it says if there's additional investigation necessary, that the court shall direct that additional investigation to determine paternity.
So you're saying that we should interpret the term ascertain to mean after a DNA test?
Well, I think ascertain means with certainty.
Well, but how could there be certainty other than with a DNA test?
Well, I think sometimes certainty can be testimony by both parties that they in fact engaged in intercourse around the time of the child's conception, and that they both believed that there was no other potential person that could be the child's father. I think certainty could be many different things, but at this point, the court had nothing before it other than that for the first time in over 2 years nearly, this gentleman's name was mentioned.
But this same section is instructing that the court may inquire of any known person. It says, may order the petitioner to conduct a diligent search. It doesn't say that you have to establish by DNA or testimonial or other processes that the name or identity of the parent, that they've got it right at that point.
No, but again, 1105E does say that additional investigation can happen if there is uncertainty, and that's what we held that the court did in this case.
But the problem, it seems to me, with the position you're asking us to adopt in terms of what this statute means, is that it then allows, if we agree with you that the filing of an amended, in these proceedings, these type of proceedings, that the filing of an amended petition essentially negates everything that happened before, then the legislative intent that there be an effort to identify the parent, you know, within a 10-day period, they're supposed to be beginning to ascertain the name or identity, that just no longer applies. I mean, it just doesn't, it has no more force or meaning, because in every case, the department can take as long as it wants and just file an amended petition later on.
And there's sort of two parts to answer that. I'll say first, I would direct the court to MM. MM is a case in which the court held that DSS and the trial court fully complied with the mandates of 7B1105, and that the respondent appellant was properly added as a party. In that particular case, the 7B11 hearing did not happen until 42 days after the filing of the.
But I really want to focus not on the hearing, but on whether or not the father, the parent, has been summoned and becomes part of the court proceeding, gets appointed counsel, can learn their rights, and can be involved.
And I'll tell you, in MM, there were several other fathers that were named. There were, I believe, 2 other people who had been named and were DNA tested before this final, I guess, third person was named and DNA tested, and then summoned. And so I believe in that particular example, there are oftentimes multiple people who are named as potential fathers. There are oftentimes multiple people that are DNA tested and excluded before we get to that point. So if every person, if we could not ascertain that a person was the father with some certainty, if we joined that person, DNA tested them, determined they were not to be the father, then are we to hold another 1105 hearing to determine who might be the next potential father? Are we then supposed to join that person and DNA test that person? And that just becomes a procedural situation that makes things last much longer than they are necessary to last. We may have to test upwards of 3 and 4 people sometimes to ascertain who is the father of a child.
But here, there was only one person subsequently named as the father, correct? And I guess what I'm curious about then is, are you suggesting it's sort of just up to the department's discretion and the trial court's discretion whether or not they follow the statute?
Well, in this particular case, that person wasn't named until 62 days after the petition had been filed. So had the court in this case followed the mandate, had the hearing within 10 days, no person would have been identified. That mother was not served with the petition until 37 days after filing, when she was arrested and put in custody. she was not having contact, she was not taking part in these proceedings. So had a hearing been held within 10 days, 27 days prior to the mother being served, there would have been no evidence of any other person to go before the court to even ask to address that. And the court would have directed that the department publish on John Doe, as it did in the alternative in the 1105 hearing here, that if this gentleman did not test to be the father by DNA, that the department proceed with publishing on a John Doe.
Right, but I still want to be focusing on, once the court had a name, doesn't this statute require the court to then summons him, make him part of the procedure, appoint him an attorney, and then proceed?
I think because this statute allows 3 different ways for the case to proceed. It allows 1, to summons him under 1105B, 2, to determine that they couldn't determine who the father was and proceed under 1105D, and 3, to direct there to be further investigation. And that's what the trial court in this case decided to do, was decide that there needed to be further investigation, and directed that the department DNA test the father and then file an amended petition if he was in fact the father. Because it says, the court shall issue order required pursuant to subsections B and D of this section within 30 days, unless the court determines that additional time for investigation is required. And so here, in our particular case, the court determined that there was additional investigation that was required and directed that the department DNA test the father to go forward with that. Additionally, as to the issue of if there was just an amended petition, you could always sort of do that amended petition to go forward. In my additional authority, I submitted LOK to the court. In that particular case, it is important that we look at how a juvenile proceeding is different from those regular civil proceedings. The regular civil proceeding, you may want to refer back to a statute of limitations date. You may want to do an amended complaint to go back to that date. In a juvenile case, the juvenile court's jurisdiction continues until the court terminates its jurisdiction or until the child reaches the age of 18. They continue with the same case number through that whole time. So, but for the petition having the title of amended petition, it could have just been a new petition. A new petition could have been filed under that case number at any given time, a new summons issued, and that father summons to court, which is what happened with the amended petition. In a civil case, if you can't have an amended petition, if the court does not give leave for an amended petition, you file a new case, you get a new CVD number, you move forward with that. In this matter, obviously, any new petition or any subsequent petition, if perchance the Court of Appeals were to be upheld, we go back, the new petition that gets filed in this case at a later point will be under the exact same case number. So there's no distinction necessarily in juvenile between a new proceeding and an old proceeding, so they're not issued a new case number in that case.
Counsel, you're well within your co-counsel time. Up to you.
I will point out to the court that I think BLH has been presented to the court. In that case, it does speak to amendments. It speaks to amendments, specifically those to conform to the testimony that had already been presented at a TPR. This is obviously not applicable in this case. In our additional authorities, I've included 3 cases, SMV, JSC, and SP. All are unpublished and obviously not controlling, but all do address amended petitions to specifically draw a distinction between BLH and their cases. They all allow. WIM, which was cited by Justice Dillon, also addresses that an amended petition and the issuance of a new summons initiate a new termination proceeding. Specifically, that is addressing a termination proceeding. And the argument's been made, 7B does not give a procedure specifically for amendment. However, SDW does say, if 7B sets out a specific procedure, that is the procedure, but the rules of civil procedure apply, and they fill in those gaps. And specifically, in SDW, the court said a commencement of a termination action under 7B clearly overlapped the procedures set out by the rules of civil procedure as to the commencement of other actions. So SDW says that as to the commencement of a procedure under 7B, that those are overlapped by the rules of civil procedure for the commencement of a civil action. If there are no more questions as to this topic, I would go ahead and allow my colleague to speak.
Thank you, counsel.
Good morning, Chief Justice Newby and Associate Justices of the Court. May it please the Court, I'm Michelle Formityville Lynch on behalf of the Child and the Guardian Ad Litem Program. This Court should reverse the opinion of the Court of Appeals because it made several mistakes in its ruling. First, it considered the father's argument as to failure to follow a statutory mandate when he did not object to any delay in the trial court and failed to show how the delay in the 7B 1105 hearing prejudiced him. Second, it went against precedent established by this court that in a juvenile case, an appellant must articulate any prejudice created by failure to meet a statutory deadline. Third, the Court of Appeals created an appeal for the father by analyzing the TPR grounds in its determination of prejudice when the father never challenged those grounds in its appeal. He only argued that he should not have to show any prejudice, and he did not show prejudice. Last, the Court of Appeals stated that if the 7B 1105 hearing had been held earlier, the father would have likely been identified earlier and been appointed counsel earlier. But the facts indicate the opposite. The court failed to recognize that any delay in representation was mainly due to the failure of the father to identify himself and complete the DNA test when it was first scheduled in May of 2020. If he had followed through with that test that was scheduled immediately after that February 7B 1105 hearing, he would have been identified, and most likely we wouldn't be here today. Addressing what Justice Earle's question, 7B 1105E, it does state that an order naming the father has to be entered within 30 days unless further investigation is necessary. And as my colleague pointed out, the court clearly stated further investigation was necessary because they wanted to get the DNA. You can't affirmatively name a father unless you have DNA or you have some testimony from those involved. And the father, obviously, from the record, he knew he was the father. He knew the mother was pregnant in 2015. The record establishes that he was told, was given notice of this child, that he was the child's father in 2018. There was nothing that kept this father from asserting his rights prior to or after the 7B 1105 hearing. And the facts of this case showed that any delay that was here actually worked to his benefits. A lot of time in a TPR case, the parents want more time. They want more time to show that they can be a better parent for their child. In this case, the father's now saying, well, that delay hindered me from creating a case for myself. But a TPR is not about creating a case. It is about being the parent to that child and what your actions towards that child have been from the time that child is born or the petition that is filed up to the TPR hearing. If that hearing had been held within the time that he alleges, most likely he would not have been identified because no one had ever heard of him except the mother, who at that time could not be found. She was found in January when she was arrested. If that hearing had been held within 10 to 30 days, no one could have identified him. There would probably have been notice by publication, and probably there would have been a TPR of an unknown father, because nothing shows that this father would ever have received that notice of publication. The father in his brief asked you to take judicial notice of his criminal record, and we would agree you should. That record shows that he was incarcerated during that time, I believe, in Catawba County or Iredell County. He was not even in Wilkes County, where this case came from. The father does argue that he was identified at the hearing on February 10th, and it's already been discussed. He was not affirmatively identified at that hearing. He was named as a potential father, and the court took that into consideration and ordered DNA testing immediately, and ordered that if the DNA test did not show that Mr. Miller was the father, that DSS could serve notice by publication to an unknown father. If the father had submitted to the DNA testing in May 2020, like I said, we probably would not be here today. The COVID pandemic started around that time. There were delays, but then he was affirmatively identified in February of 2021 when that was presented to the court. The court immediately made an order finding that he was the father. He was summoned in the underlying neglect proceeding soon after that. The Court of Appeals did not recognize that the trial court found that the father was told by the mother that he was Kim's father in 2018. Those findings were not challenged and therefore are binding on the appeal. The Court of Appeals stated that he did not know until the DNA testing was completed in 2021. We submit, as a matter of law, the findings of the trial court supported the adjudication of abandonment and neglect, and the Court of Appeals did not quote or recognize many of those findings that did support the TPR adjudication. Analysis of the TPR grounds would have been proper if the father had brought that argument to the court, but it did not bring that argument to the court. And this court has stated many times the appellate court is not here to create an appeal or create an argument for the appellant, and he just merely did not do that. The Court of Appeals stated that it was likely he would have been identified if the hearing had been held earlier. I don't think likely is accurate here at all, as we have shown. There most likely would have been an unknown father and notice by publication. Child welfare cases are not about preparing a case. They're about the status of the child, and you have to look at what this father did, and he basically did very little, if anything, to assert his rights as a parent. The ruling, I'm going to cut now because I'm going into our rebuttal time. The ruling of the Court of Appeals goes against precedent established by this court. The father failed to show prejudice or reversible error by the trial court. Therefore, we'd ask you to reverse the Court of Appeals and affirm the ruling of the trial court.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
Thank you, Your Honor. May it please the court, my name is Lee Gillum. I'm from the Office of Parent Defender, and I represent the respondent father in this case. Now, the Court of Appeals announced a very simple and fair rule in this case. And its rule is the trial court may not terminate the parental rights of a father who was not identified in the original petition, was not timely identified by DSS in the trial court, and was not given a reasonable opportunity to form a relationship with his child after being identified. And I couldn't agree more that juvenile cases are not about preparing a case, but I think this case is about giving a father an opportunity to know his child and form a relationship with him in a circumstance like this. And I think that's exactly what Section 7B-1105 A and B are all about. It's not about making sure the father can attend a hearing. It's about identifying the father so that a relationship can be formed. And that's not only fundamentally fair to the father, I think it's fundamentally fair to the child as well, because Mr. Miller, when he appeared in court, and when he wrote his letter to the court after getting the termination petition, said, I know what it's like to have your father taken away from you. I know what it's like to not know your father when you grow up. And he said, I want for my child not to have the same experience that I did and know her father. And so these procedural protections are not only for parents, but also for the children. I think 7B1105 is meant for situations exactly like what happened here. The mother of the child knew all along who the father was. And as DSS pointed out in their brief, there were two people that had the best reason to know who the father was. One is the mother, and one was the father. And the mother, back in 2015, when she found out she was pregnant, she told the respondent father, I'm just going to have an abortion. I'm done with you. We don't need to worry about this child because I'm going to have an abortion. And after that point, she shut him out of the child's life. And for 3 years, up until DSS took custody of the child, she held out that her current boyfriend was the father of the child and made no mention to anyone that, as far as the record goes, that respondent father was actually the child's father. And she maintained this position for the first year after the child was taken into custody by DSS. A lot was made in the dissent of the Court of Appeals, and a lot's been made in oral argument about the father knowing who the child was in 2018 and failing to establish a relationship. And it was attorney oversight not to directly challenge finding 32 that says he saw pictures in 2018, but in December 2021, the trial court found that he did not know that she existed until he was approached for DNA testing. That is a finding of the trial court. It's on page 262 of the record, finding of fact number 17. So for the trial court to then come back 6 months later and find that he knew in 2018, I don't know how you reconcile that. And that finding from December 2021, it wasn't contradicted by the testimony at trial.
Can I ask a practical
Sure.
question? If we adopt your position, if we were to affirm the Court of Appeals, what happens going forward? Is there now sort of further permanency planning with your client? Or what would be the state of the matter? So the termination wouldn't take place, but where would we be then procedurally?
Well, I think the answer to that question comes from the July 2019 permanency planning order when the questions were first raised. And the trial court found on the recommendation of DSS that we should leave reunification, at least as a secondary plan. We've got adoption as primary. We should leave reunification as a secondary plan because we don't know who the father is yet. And that implies to me that ceasing reunification has to be based on some kind of fault on the part of the parent. They haven't done anything with the case plan. They're not staying in contact with the Department of Social Services. There has to be some kind of finding of fault on the part of the parent. And so I think they acknowledged in July 2019 that, yeah, we need to leave reunification in here because when we find this unknown father, we have to give him a chance. And when they did, they changed the plan after that. But when they did find the unknown father, I think they had to give him a chance. They had to give him an opportunity to form a relationship with the child. And the social worker knew definitively in January of 2020 who the father was because her testimony was that I saw the mother, she gave me a name, I went to the public records of incarceration, I found his picture, I went back to the jail because she said she went twice to the jail. That's on page 142 in the record. She went back to the jail and she said, is it this guy? And the mom said, yes, he is the guy who is the father. Now,
So I would take it then that you do not agree that in the statute, the word ascertain means that that has to be after there's a DNA test.
no, and I think there's case law to support that. I cited Nash DSS in my brief, and that was a case where the court held that the testimony of the putative father trumped the DNA test because the trial court heard that testimony and made a finding by clear and convincing evidence as to who the father was, and the court disregarded the results of the DNA test. So I think it's completely incorrect to say that you have to have a DNA test to conclusively identify, because there was time at this point. There was still 2 weeks before the hearing, and there was no reason why the trial court, mom was incarcerated, respondent father was incarcerated. There was no reason why the trial court couldn't have called them both to court for that preliminary hearing, which 1105B does give the court the discretion to do. You can call the known parent and ask them. He could have called them both to testify and said, the social worker told me that, Mom, you identified that man as the father of your child, and tell me, is that the truth or not? And then it would have had most definitely a decisive answer as to who the father was. But instead of calling the two parties to court, the social worker testified, well, when she told me his name conclusively, I called the legal department. And then she did not make any effort whatsoever to contact him until April of 2020. And that's 3 months that have gone by after the mom has identified him. So to go back to my earlier point, if I may, about the father not knowing about the child in 2018 and the...
Let me ask you this. Would you agree that the statute with regard to neglect, abandonment, you look back over the prior 6-month period and see what contact, if any, has been made with the child? You agree with that?
Yes, and the Court of Appeals... Yeah, go ahead.
And so the trial court, in its order, said that for 6 months preceding the filing of the petition, that the respondent had willfully made no contact with the minor child. That wasn't challenged in your brief, was it?
Yes, I did challenge that in my brief.
Can you point at the Court of Appeals? Can you show me where that was challenged? I know it wasn't, you didn't sign that brief. But.
No, I took the case over, but there was a challenge to, looking back at the appellant's brief to the Court of Appeals. It said, on page 21 of the brief, it said the court should disregard the finding that Mr. M did not attempt to establish a bond with Kim or maintain contact with DSS to inquire about her well-being.
So that was not specifically conclusion of law number 5. What you're talking about is a specific finding of fact that the trial court made, correct?
Right, well, that was finding 40, according to my notes here. That was finding 40, that he did not attempt to establish a bond with her or maintain contact with DSS.
And again, looking at the 6-month period, the context of that challenge was with regard to prejudice based upon the argument that the trial court violated 1105, correct?
Right.
So it was not per se, if you will, a
Right.
challenge other than to say, well, these may be ways that we were challenged or that we were prejudiced,
Yeah.
correct?
And I think that reading would exalt form over substance, because the ultimate question in this case, which is what the Court of Appeals addressed, is did the father, based on the circumstances and the limitations on him, attempt to form a relationship with the child? And the Court of Appeals did.
And you look at the 6-month period, right?
Right.
And there's nothing specifically, no letters, no gifts, no attempt to communicate. There's nothing that happened over that 6-month period, correct?
Right, and the Court of Appeals said that he requested the pictures of the child and sent the district court a handwritten pro se letter.
So do we know when those occurred?
I don't think that we do.
So
At
those
least not
could have been,
sent the child a letter. It
those
was,
could have been,
yeah.
he was immediately, or when he was told in February, which is 8 months before, as opposed to within the 6 months. And you didn't put forward, the brief at the Court of Appeals didn't put forward any argument as to why the court, why in the view of the brief writer, that the court, or that the appellate court shouldn't look at that finding, but it didn't make an argument. It didn't say, well, the record shows it's wrong because of, none of that, correct?
Right, right. So, but the Court of Appeals, it did find prejudice in these findings, that he didn't have any, he didn't make any contact with the child. And that's because, like I said, prior to being approached for DNA testing, he didn't know. And then after that, and we don't know the dates, so you'd have to establish, A, that letter was not written during the relevant dates, because there was no testimony about that.
Who has the burden to establish that, trial court, you say that there was no contact within 6 months. The trial court's wrong because there were these efforts within 6 months. Who has that burden?
DSS always has the burden to prove any termination ground by clear and convincing evidence, and that includes abandonment.
So on appeal, in your view, you don't have to specifically challenge and then provide record evidence that would support that challenge?
I think in this case, because there was a statutory violation, and the analysis then is prejudice, that it wasn't necessary to specifically attack those findings.
And that's pretty much what you said, or what was said in the brief.
Right.
The brief basically said that the court doesn't need to reach prejudice. Matter of fact, on page 20, the court should vacate trial court order without requiring the birth father to show prejudice.
Right, right. And I think that's a reasonable take on K.M.W. There's some errors in the proceeding that are so grave that they infect the entire proceeding, and they are error per se. And I think you could find, the Court of Appeals did not find error per se, but I think you could. I think you could find error per se, that when there's no timely hearing under Section 7B1105, and then beyond that, there are many chances where DSS could have given the father an opportunity to form a relationship, but they didn't do it, then the case can be vacated just on that basis alone. And the Court of Appeals cited DMO, DEM, and KN, and they said you can't find abandonment unless you find that the father had some opportunity, or the parent had some opportunity to form a relationship. And the opportunity to form a relationship circles right back around to not only the late hearing for the 1105A hearing, it's not only that, if that had been all there was to it, then this case might have been affirmed. But there was more than that. It was, waiting for 3 months after the father was definitively named. It was not calling the parents to the preliminary hearing to inquire. The DNA test, for sure, was was delayed by COVID, and I don't think the record supports the fact that the respondent father was out of incarceration in May of 2020, and that's why he missed the DNA test. It is more likely, if you look at the incarceration records, that he is simply being transferred from one jail to another. But again, DSS has the burden of establishing grounds by clear and convincing evidence. So we had this delay for even talking to him. We had, even after he was conclusively identified with the DNA test, there was a permanency planning hearing in June of 2021, and that's when, after that hearing, he was appointed counsel. And the Court of Appeals didn't mention this, but that order wasn't even entered until after the termination hearing on grounds. So it was 10 months before we got this order that, said, no, the plan still has to be no reunification efforts. And then after in October 2021, when he was served with the TPR petition, he was given the name of his lawyer. And that apparently made a big difference in the case, because in December 2021, which is, of course, outside the statutory timeline, the court made a finding he didn't know the child existed until 2020. And I think the Court of Appeals said he did what he could after he was identified, because there's certainly case law that says you can look beyond the particular statutory time frame for the respondent's intentions as to whether the respondent intentionally abandoned the child. And in this case, I don't think the record supports that.
Can I ask you maybe a slightly different question about prejudice? And that's following up on this court's precedent from December of 2020 in Re K.P.W, where we said very clearly, finally, we declined to adopt the guardian ad litem suggestion that we require a showing of prejudice as a prerequisite for obtaining an award of appellate relief in cases involving the erroneous deprivation of the right to counsel. In the criminal context, no showing of prejudice is required in instances like this one, and we declined to adopt a different rule for use and termination of parental rights proceedings. So in that case, the issue was whether or not the parent had representation. And it seems to me here we have a very analogous situation, because particularly the failure to add him as a named to add him when they first had his name, when they first had the mother, as you described, the mother looked at the picture, said, yes, that's the father. Their failure to add him and then appoint him counsel, he was unrepresented for the bulk of the time that this proceeding was underway, correct?
No, that is my understanding as well. And after DSS called him and said, this is your child, we're certain about that, and so he asked for pictures, he sends a letter, then it's a bit of a got you there for him, because he's waiting, right, for a response to a letter from his child. He's waiting for the department to, say, here's what you can do. When he was served with the termination petition, he wrote a letter to the court and said, please don't terminate my rights. And again, I think it's really important in this case that he knew what it was like to have his father taken away. He knew that. And that is, I think, why you can't say that he intentionally abandoned this child, because So he said, my child needs to know her father, and I'm here, and I want to participate. And, you know, when he doesn't get a response to his letter from DSS, I mean, I don't think he really knows what's going on, because there's no indication at all that the social worker called him back up and said, you know, here's what you can do to come back with your child. And that was the problem with DEMO, DEM, and KN, that the court didn't make any findings about any opportunity he had. And the record in this case doesn't show that the respondent father had any opportunity after, in that 6-month window, to make any kind of parenting overture to the child, because DSS was in complete control of the child. They had custody of the child, and he was, you know, locked up. And you can say, well, he was locked up because he did bad things, but he was locked up, and he really couldn't do anything to reach out to the child during that time. And I do want to, I keep going back to this point that I have, and I do want to make this, that the testimony of the termination proceeding was not contrary to the trial court's finding in December of 2021 that the respondent father didn't know the child existed. Because when he was asked about seeing pictures of the child, he said he saw one picture one time. And that picture was when he was out of incarceration for 8 days. And again, looking at his record of incarceration, that was September 21st, 2020 to September 30th, 2020. So that testimony is not inconsistent with the trial court's finding. And even the social worker's testimony was not inconsistent, because when she was asked, well, did you ask him when he saw the picture? And she said, well, he didn't give me the date when he saw the picture. So there was nothing in the testimony at the hearing that contradicted the finding that he didn't know the child existed until 2020. So the Court of Appeals holding, like I said, is simple. When a father's not identified in the original petition and not timely identified by DSS in the trial court and not given a reasonable opportunity to form a relationship with his child after being identified, and that's your prejudice piece, the trial court errs when it terminates his parental rights. So there's 3 questions, I think, within that statement of law. One is, did the court err in failing to hold a preliminary hearing? And I think, yes, absolutely, the trial court erred when it did not hold that preliminary hearing in a timely fashion. And DSS counsel argued that they couldn't hold that hearing until the mother was served with the termination petition. But there's nothing in 7B1105 that tolls the time for holding that hearing on an unknown father pending service of the termination order. The other question is, was the error cured merely by the filing of the second petition? And I think the answer to that question is no. And the reason I think the answer to that question is no is, as the Court of Appeals said, these procedural protections are meant to allow a previously unidentified father a fair opportunity to be involved in the child's life. And that absolutely did not happen here, and that statement by the Court of Appeals is perfectly consistent with fundamental fairness. Fundamental fairness not only to a parent, but also to a child who's going to lose their father without the father ever having any possibility of being involved in the child's life. And there was reference to MM, and MM was another case where the father wasn't identified in the original petition, and the ground there was 7B1111A5, and 7B1111A5 would not have still been useful if the position that DSS is taking today had been argued in MM. In MM, the argument was that no, the The second petition that it merely includes the biological father's name is not a new action, because we want to use that first date of filing to serve our purpose to use 7B1111A5, which is fixed at the time of the filing of the termination petition. And MM specifically stated that the rule of Ziegler and Burrell, the 100-year-old rule, that an amended pleading supersedes the original petition, specifically stated that that rule does not apply when the question is regarding a hearing and adding a parent to the petition under 7B1105. And the reasoning for that is because there's a specific rule in the juvenile code that clears and makes the rules of civil procedure not apply. And then the third question that this case asks is, did the uncured, and it was a compounded error because of the many delays that we saw from DSS, it was a compounded error, cause prejudice to respondent father? And the answer to that question is yes. And the Court of Appeals didn't cite NRA-JS from this court, but it certainly is consistent with NRA-JS. And JS says that constructive and positive parenting can occur and parent-child bonds can be meaningful while a parent is incarcerated. So the respondent father did not get a fair chance at all to develop these bonds and exercise constructive and positive parenting. And it was because the department did not give him that opportunity. And for that reason, that error caused prejudice to respondent father. And with or without a showing of prejudice, I think you could affirm the Court of Appeals as per se error. But at the very least, I think the rule of the Court of Appeals can be adopted when a father is not identified in the original petition, not timely identified by DSS in the trial court, and not given a reasonable opportunity to form a relationship with his child after being identified, the trial court errs when it terminates his parental rights. So if there's no other questions?
Thank you, counsel. Rebuttal.
Thank you. The record in this case shows that the 7B 1105 hearing was held. There was a delay in it, but it was not an egregious delay. And the purpose of 7B 1105 is to find the father, and he was found. So 7B 1105 basically has a remedy when you don't know who the father is. The father was found. The father's counsel keeps indicating that he did not know he was the father, I think, until the DNA test in 2021, that the court made that finding in a prior permanency planning hearing. I would just submit, at the time of the TPR hearing, the court had more information. It had more information because the father actually testified at the TPR hearing. The findings that the court made, and they were based on Mr. Miller's testimony. He stated he was contacted by the mother on the phone, on Facebook. He saw pictures of the child in 2018. The mother told him he was the minor child's father. That's the finding in the TPR order that he was told by her in 2018. He admitted he was relatively sure he was the minor child's father when he was contacted about the DNA testing. Now, as to prejudice, K.P.W. was the case where this court found that there was, you did not have to show prejudice per se, that it was error per se. And in that case, that concerned the notice of withdrawal and the mother's withdrawal of counsel a few months before the TPR hearing, whether it was proper that the court allowed her attorney to withdraw, and then when she showed up late at the TPR hearing, should the court have inquired of her at that time, do you want assistance of counsel, when she had already signed a waiver of counsel? The majority of this court did find there was prejudice shown, or that was prejudice per se. There was a dissent in that case by Justice Morgan that was joined in by Chief Justice Newby, and I would ask you to look at that dissent. But that is not the case here. This is a case about prejudice in regards to a deadline. This court, per curiam, adopted the Court of Appeals dissent in JZM in 2007, and that established when there is a statutory deadline that is not met, you have to articulate the prejudice. And that is what applies to this case. The Court of Appeals even mentioned JZM. They cited that case in their opinion, but they did not follow the ruling of this court in that case. Reunification is about reuniting a child with their parent. Reasonable efforts are keeping the child remaining or reuniting them with a parent. This is the case that begs the question, how do you reunite when the father is a complete stranger to the child? She is 9 years old now. She has never met this man. He has 3 other daughters. He has never been a father or provided a home to them, as far as we know. His letter to the court in response to the TPR petition basically stated he wanted to know her, he wanted her to know his family, and he would like visitation. That's all he asked for in his letter responding to the TPR petition. We would submit this father had plenty of time to get to know this child. Any delay in a 7B1105 hearing or naming him, that was not the main cause of any prejudice towards him in knowing his child. The prejudice was his actions and failure to follow up and be a father to this child. We ask that you reverse the ruling of the Court of Appeals. Thank you.
Thank you, counsel. Thank you both. Support.